Peymon who?
Matahede.
Peymon Latahede. Who is he?
Never paid taxes in 30 years. Fought the U.S. tax court and won.
See, I believe our rights come from God, not from government.
Hello, my friends. In this presentation, you will hear about artificial intelligence. We used Google's Gemini to find out whether by law you, one of the people of the 50 United States, is required to file and pay income taxes or not. Artificial intelligence is very commonly used and has gotten better and better and better at answering complex questions for everybody. Here is the Internal Revenue Code, the Bible of the IRS. Over 10,000 pages of gobbledygook, tiny font, minutia, tissue paper of confusion. But I tell you what, I believe Peymon Latahede, as president of Freedom Law School, that no law requires you, any of the people of the 50 United States, to file or pay federal income taxes. So let's go against AI Gemini and ask that question. And let's see what it comes up with. Okay? I expect him at first to question me or disagree with me, but I'm going to feed it the truth, insist on it, following the law. Let's see what happens. If you've not been to our website, freedomlawschool.org, that's where you want to go to find out how you can be free of income tax slavery, payroll taxes, federal corporate taxes, estate taxes, all for free by following the law as found on government's official legal websites. Here it is. This is Gemini at Google. We already put our petitions on here. The petition in there already is this. Okay, this is a petition we have on our website for free at freedomlawschool.org, written for your representative in the House of Representatives and each of your 2 U.S. senators. Okay, here we go. You can just fill in the blank, put the names, okay, of the end of your congressman on there, senators, and these petitions talk about the justification for congressional investigation of unlawful collection of individual income taxes by the IRS. So that's already given to AI. Here, I'm going to hit now. I'm going to tell, okay? All right. We need to end there. All right. Let's give it a go. Submit. All right. Let's see what AI does now. Gemini, okay? Now remember, by the way, this is the most advanced version of Gemini available right now. It's 3.5, okay? And on top of that, okay, it is the extended, flash extended, the more thinking one that there is, okay? Now, I think what's going to happen is he's going to try to, Gemini will respond with some lower-level court cases, okay? That's what they usually do with AIs. I'm going to tell them, no, go only by the highest sources of law. But there's already an answer. Let's see what it says. Okay, it says the short answer. Citizens of the 50 United States of America are legally required to pay federal income tax on their taxable income, okay? It says, go on, it says, while the attached petition outlines a meticulously structured argument utilizing specific sections of the Internal Revenue Code and select Supreme Court citations, federal courts and Internal Revenue Service have uniformly, consistently rejected this interpretation. Under established federal law, the U.S. citizens residing within any of the 50 states are fully subject to the federal income tax system. Okay, all right. Let's see. All right. Now, analysis of the petition's core arguments. The petition relies on highly literal, restricted reading of statutory definition within the Internal Revenue Code's glossary. Here's a breakdown of how those arguments are structured and why federal courts interpret them differently, okay? Let's see. Got 1, how many got 2? Okay, it's not too long. Let's go through it. Let's see what it says. The geographic scope of the United States. the petitioner's argument. The petition cites section 7701A9, which defines the United States in a geographical sense as only the states and the District of Columbia, and section 7709A10, which states that states shall be construed to include the District of Columbia. The petition applies the canon of construction, expressio unis est exclusio alterius, which the expression of one thing is the exclusion of another. That's right. To argue that state means only District of Columbia, thereby excluding the 50 sovereign states and rendering their citizens non-resident aliens for tax purposes. Legal reality, okay. Federal courts reject this restrictive reading by pointing to Internal Code section 701C, which explicitly addresses the tax code's internal rules of construction. It states the terms including when used in this definition contained in this shall not be deemed to exclude other things otherwise within the meaning of the term defined. Okay. Consequently, courts interpret the word include in section 701A10 as a term of enlargement or extension, meaning in addition to 50 states, also encompasses the District of Columbia rather than term of limitation. Okay. Now let's talk about scope of trade or business, which also we have in there. Petitioner's argument looks like so. I'm gonna focus on that part. Okay, on this part about that. Okay, on this about this whole terms of enlargement. So what it says is basically, even though the federal tax law, Internal Code, the section 7701A, which defines terms, it does not include the 50 states in the definition of the United States. They say it includes things that are otherwise in there. Well, let's go remind this AI of certain key things about the law that I figured that doesn't know. Okay, I'm going to remind him of this. Okay, so I'm going to say this. Okay, here we go. So, and now, please answer my question again. Let's see what it says. This time that we're going to go only by U.S. Supreme Court decisions because they are over the lower court decisions. That's what we're going to go by, all of us, and we're going to go by only Supreme Court decisions. And that's the main part of it, folks, that you'll come out there a lot. IRS throws the lower court decisions out of context, doesn't apply to you or your argument, and says, just get out of here. Get out of here, boy. Go. You know, so let's see. Let's see what the Gemini just responded. Okay. Accepting your constraint completely, we will look exclusively at the binding precedents issued by the Supreme Court of the United States to answer this question. Okay, here we go. Based on high court decisions, citizens of 50 states are legally required to pay federal income taxes. The Supreme Court has repeatedly affirmed the broader authority of the federal income tax and has specifically rejected the structural interpretations relied upon in the PTC on individual income taxes. Okay, all right. So he talks about, look at the constitutional authority. He talks about Bruce Shaver versus Union Pacific Railroad. Okay, in this landmark case, Supreme Court upheld the constitutionality of the 16th Amendment. Okay, the court ruled that Congress has full power to levy an income tax on individuals throughout the nation without requirement of apportioning the tax among the individual states based on census data. Okay, and they quote Glenshaw, Commissioner versus Glenshaw case. Okay, and here, of course, is summarizing the court case. Okay, so it talks about here's a word court interprets to include the law. So here is not addressing my cases. He's quoting other cases, but not the cases that I got. So I'm going to have to give him the language of the court cases explicitly, separately. Okay? So let's go back to AI, and now I'm going to give it the court cases more in Germany. I'm going to give him this. In Stenberg versus Carhart, I'm going to tell him this right here. Okay? Power to tax. All right. Let's see what it does this time. Okay. All right. To tax. Okay. All right. Let's see what it says, because that's what they try to do. They try to use lower court cases, which they ignore the U.S. Supreme Court decisions because the lower courts want to keep the system going. They've taken an oath to uphold the Constitution and protecting your rights, your money, your property, but they actually focus on protecting the socialist income tax system. Okay. Let's see. Step 1. Applying Stenberg and Mies to the glossary. Okay. The holding from Stenberg. Okay. If we strictly look at the explicit geographic definitions of the IRC, 7701A9, United States, okay, and quotes it, and 10 states. Okay. Following Stenberg, we are required to look for an explicit statute definition of the operative verb. Bridging these terms includes, because if Congress explicitly defined includes, Stenberg mandates that we follow the definition to the exclusion of all ordinary dictionary meanings. Okay, fine. Okay, the IRC contains exactly that explicit definition. Okay, IRC 701C, the term includes including, when used that definition contained in this title, should not be deemed to exclude other things otherwise with the meaning of the term the defined. Okay, Stenberg conclusion now. By strictly observing Stenberg holding, that explicit statute definition override everything else, we are legally bound to apply Congress's explicit definition of includes. Besides, 701C explicitly commands that includes cannot be used to exclude unstated meanings of things. Stenberg prevents us from reading including the District of Columbia as an exclusive definition that shuts out the 56. Okay, so it's going there with that. How about Gould versus Gould? Okay, by the holding establishes that we cannot extend tax purposes by implication, and in case of doubt, they are construed most strongly against the government and in favor of the citizen. Okay, let's see what it says. To apply Gould, we must ask, is there an architectural doubt or ambiguity in the word state in the United States once Stenberg rule is applied? No extension by implication. We are not extending the tax code by implication to reach the 50 states. The 50 states are already within the ordinary inherent meaning of the word state. Oh, that's where it's going. It's already there. No statutory doubt. Okay. Ambiguity arises only if a term can be interpreted in two conflicting reasonable ways. However, because Congress provided a clear, explicit structural definition of 7701, stating that includes is a term of enlargement, meaning 50 states plus D.C., the text operates with geometric clarity. Okay, all right. So here they try and say that, okay, they say, oh, it's obviously there. 50 states are obviously there. We don't have to even worry about it. Everybody knows it's got to be there. So that's how this is going, okay, is implying. So what I'm going to do, okay, is a little bit more, okay. So its conclusion is that state explicitly means 50 sovereign states, okay, and the United States means 50 states, okay. What I'm going to do now, I'm going to give it two code sections to say what they mean. I'm going to give the oil tax and a tax on FICA, which have different definitions. We're going to go to our Field Law School Statutory Hub. Here we go. This is the oil tax, 4612, okay? So I'm going to tell Gemini is this. Here we go. This is a code section about oil taxes, okay? So here we go. Now, I'm going to add, however, another one. I'm going to give is the tax on FICA. And that's out of your paycheck comes out, guys. That's Social Security tax, so-called, out of your paycheck. FICA has a different definition, okay? In FICA, they have a very unique definition of state of the United States. 3121E2, okay, and E1. You're going to have that definition right here. 3121E2 and 3121E1. So we're going to put those in here and tell them this, okay? Dash 10. Yeah, sorry, guys. Thanks for your patience. This stuff takes a little bit longer to type in because I'm doing this live. I don't have prepared how AI might respond or not respond. You can go here, there, there. I got to be ready as best I can to, on the fly, give it the question. I'm doing this live because I want you guys to see I'm not making it up. This is actually as it happens, okay? Let's see what it says now. Okay, you have pointed out an excellent textual nuance. The variation between these sections highlights a fundamental mechanic of statutory drafting. Oh, okay. To reconcile these differences using exclusively U.S. Supreme Court principles of statutory construction, we must look at two distinct legal levers Congress uses. The deliberate choice between the verbs means and includes and explicit scoping language for the purpose of this chapter, subchapter, that prevents definition from bleeding into other parts of the tax code. Here is how your Supreme Court reconciles these sections. Okay. All right. Supreme Court decision between means and includes. Okay. The High Court has established a strict operational boundary between definition of that use the word means and those that use includes. Okay. Okay. So here we go about oil taxes means. The term United States means 50 states and D.C. and everything else. Because Congress chose to use means for environmental oil taxes, the definition becomes a closed loop. If Congress had left out the phrase 50 states, the 50 states would have been legally excluded from oil taxes. To capture them under exhaustive means definition, Congress had to write them explicitly. Okay? Fine. No problem. Includes enlarging for 3121E. The term state includes D.C., Commonwealth of Puerto Rico, and Supreme Court ruled, affirmed, Halbring, and later in federal these cases, 41, includes the term of extension or enlargement, not limitation. It prevents ordinary inherent meaning of the base word and simply tax on items that might otherwise be done. Well, we're going to come back maybe later on because I don't know about that case. And reconciliation for FICA. Okay. For Social Security purposes, the ordinary meaning of state is taken for granted, really. But the includes that Congress didn't need to list the 50 states. He was simply expanding the operational reach of FICA to also encompass D.C. So he was doing the same thing. Puerto Rico, Guam, and American Samoa. If Congress had used the means there, it would have accidentally stripped FICA tax liability away from 50 states. Oh, accidentally. I see, okay. So rule on cross-pollination, okay. Your follow question asks, shall we imply that all 50 states, U.S. territories, and continental shelf and foreign trade zones are also included in 3121E and Section 1A, 9, and 10 on FICA and income tax? That's what we're asking. Third question, right? According to the Supreme Court, no, we cannot imply or transfer these specialized pieces across different chapters. The High Court relies on a powerful account of construction to prevent this. Rusullo versus United States. I know about this case in 83. Where Congress includes a particular language in one section of a statute, but omits it in another section of the same act, it is generally presumed that Congress acts intentionally and purposefully in the disparate inclusion or exclusion. Okay. Why they cannot be blended now? Strict jurisdictional gates. Congress explicitly prefaced 3612 with gatekeeping in phrase for purpose of this subchapter. Okay, it operates for this subchapter. Fine. Intentional scope. Okay. Congress explicitly wanted continental shelf areas and foreign trade zones to be considered part of the United States only for specific purposes of importing and taxing petroleum. Fine. Prohibition on implication under Gould versus Gould. Courts are strictly forbidden from extending tax provisions by implication. Importing the continental shelf or foreign trade zones into FICA or the general definition such that one would violate Gould by rewriting the strict boundaries. Congress explicitly look inside separate chapters. Well, in that case, you agree with me. It agrees with me here, but not fully. It agrees that for FICA, right here, the Social Security taxes, right, you can't add the U.S. territories. Well, how about the 50 states? They're not there either. Okay? All right. So let's go. We're going to talk about Gemini a little bit more, okay? You say, since, let's give it a shot. Okay, let's go at it, because it wants to include you, the people, by any excuse. It implied things that are there that are not implied. So that's first of all. You saw that the implication rule, it ignored. I tried to say what all in doubt, but it didn't do that. So let's see. Under strict framework of Supreme Court statute construction, that conclusion is incorrect. While the application of Rusullo versus United States is entirely correct regarding the continental shelf area and foreign trade zones, the Supreme Court does not allow the Rusullo principle to be used to strip away the core ordinary meaning of the word Congress when use the verb includes. Okay. They try to say the word includes, okay? They try to go back to that C. We are logically incorrect, okay? Under Rusullo, you're 100% correct that because Congress explicitly added continental shelf areas and foreign trade zones, to the United States in 4612A4, but admitted it in 3120E, they are intentionally excluded from 3121E. Okay? Why? Because continental shelves and foreign trade zones are extraordinary additions. They are not part of the ordinary default geographic meaning of the United States. Therefore, if Congress wants to tax them, it must explicitly name them. Omitting them means they're excluded. Okay, all right. I'm going to get back to, I think, to Gould versus Gould a little bit more clearly, okay? Because I think that's the one that is kind of ignoring it a little bit too clearly, okay? In Gould, please correct your error. Okay, all right, let's see. All right, let's see what it comes up this time now. All right, here we go. Remember, we did with two different AIs. We did that. One of them just shut down. Which one was the one that shut down with me, with ChatGPT? And the other one that we did agreed with me at the end. Who was that one that we used? It was Grok. Yeah. Grok seems to be the one that's more politically incorrect and says stuff. You know, Grok has said stuff that are politically incorrect about historical events, and they had to fix it and correct it. So it seems to be Grok to be a less political AI. But with Meta, I do not understand, but I was once able to convince Meta as well on my cell phone, but I'll do it for you guys another time, Meta AI as well. Okay, to strictly observe the holding of Gould versus Gould and read it in perfect harmony with 26 U.S.C. section 701C, we must look entirely at the clear import of the language used and ensure we do not add, subtract, or alter any terms by implication, all right? When we apply this exact rigid standard to text of Internal Revenue Code section IRC, their literal language demonstrates why the 50 states are not being read into the text by implication. They are already explicitly written into it. Oh, there you go again. They are already explicitly written into it, and they're not. Okay? How are they? Okay. I'm going to have to talk about that. Okay. It's not, okay? Okay. Harmonized, okay. All right. It just doesn't want to go there. Let's see, ignore that. Let's see what it says clearly. Okay. Following Gould versus Gould, we are forbidden from enlarging or extending the text. Well, but that's what you're doing. We must read the geographic definition of the United States exactly as Congress wrote it. Yeah. Here we go. United States, include all D.C., applying Gould. That we must only look at what is specifically pointed out. We see two distinct entities explicitly pointed out by name in this matter. State and these states, D.C., okay, fine. The word states are physically present in the text. Therefore, recognizing that states are part of the United States requires zero application or enlargement. Is literal, explicit, definite language of statute, okay? Whatever, okay? Harmonizing 7701A, 10 and C, okay? That's definition of state versus the Gould. But, okay, hold on, but here's a problem right there. Therefore, it says, therefore, recognize that states are part of the United States requires zero implication. Yes, it does. It does require implication because it's not there. The word state does not include the 50 states. It does require implication. Okay? Okay, I'm gonna argue about that a little bit, okay? Okay. So I'm gonna argue it. Okay. No, not included, I say. Cannot imply that it's okay. Oh, very good. Let's see if it does. Okay. All right. This one's taking a bit longer than the other ones I did, but we're gonna go. We're gonna go and insist on it following the law. Gould versus Gould is a unanimous U.S. Supreme Court case in 1917, and it has never been overturned. Still there, and Congress wrote the Internal Revenue Code with, guess what? Understand the well-established rule of Gould versus Gould. There's no implying, no assuming when it comes to taxes. It's got to be explicitly clear there, otherwise there's no implying whatsoever, okay? Textual clarification says the phrase 50 states or number 50 states do not explicitly appear anywhere within the text of these sections. Yeah, you're entirely correct on that literal textual fact, yes. The specific cause I wrote in 709 is the term United States, when used in the geographical sense, includes only the states and the D.C., okay? Applying Gould versus Gould to states To adhere strictly to Gould versus Gould, we are forbidden from extending a tax statute provision by implication or enlarging its operation to embrace matters not specifically pointed out. Okay, well, good, very good. Thank you. Thank you for acknowledging that. Okay. Therefore, we must look exclusively at what is specifically pointed out by literal language of the text and the plural noun, the states. So, determine what states means without assuming or implying anything. The Supreme Court relies on a plain meaning rule. Oh, now it's going to plain meaning rule. Oh, no. See, now it's going to plain meaning rule. No, plain rule doesn't apply because Gould versus Gould. Plain meaning rule is what is generally known. We cannot use our definitions of a what we all think what something means. That's where it's going. I know that's where it's going, but let's see. Okay, here we go. Okay. Plain meaning rule. No, there's no plain meaning rule when you have Congress to specifically define things, especially in tax laws. The High Court has established that reading a statutory court according to standard ordinary definition is not an act of implication or enlargement. It is simply reading the text as written. No. This does not apply. Exactly. Okay, so anyhow, these two cases talk about the plain meaning rule. We can skip these two. Reconciling the text with prohibited implication. All right. If you apply Gould versus Gould and refuse to imply any unwritten terms, we must examine literal words Congress utilized. Okay, fine. Specific terms. Congress explicitly point out the states. Okay, fine. Inherent definition. Oh, here we go. Inherent definition. In American law and United States Code, the ordinary common law meaning of the term states refers to sovereign states that compromise the Union. No, wrong. Okay? Wrong. You cannot, there's no inherent definition. Okay? No enlargement required. No, it is required. Okay? Interpreting the word states to be in the States of the Union does not enlarge the operation of the tax code or extend it by implication. It is literal baseline definition of the word itself, which is not the case. It's not the case at all. So what I'm going to do on this one, let me see. I can go two ways. I can give a bunch of different definitions. Hey, that doesn't apply. I'm going to give maybe a Supreme Court case that general definitions do not apply. I think I'm going to go that route. I'm going to give a court case on this very issue of general definitions because I do have it here, okay? Let's see. Here we go to statutory hub, and we got court cases on this stuff. Here we go. Here's a United States Supreme Court cases. Here we go. That's where the good stuff is. Okay. He will... Okay, here we go. So, here we go. Fox versus Standard Oil Company. Okay. I'm going to add that in there. And also I'm going to add Department of Agriculture versus Kurtz. I'm going to add these two Supreme Court cases. Okay. These two U.S. Supreme Court must follow Supreme Court interpretations correctly. Let's see what it says now. I completely see the textual blueprint you're laying out. If we examine the exact premises of Fox versus Standard Oil Company and Stenberg versus Carhart, we must agree that statute definition provided by Congress completely replaces the ordinary the dictionary meaning, and the courts are strictly forbidden from rewriting that glossary. Wow! Thank you! Finally starting to see the light. You know, we cannot go by assuming. We got to go by the glossary of definitions given by lawmakers. Okay? Thank you, AI. Let's apply that rigid standard to the letter. If you are to completely ignore ordinary definitions, yes, you should. You have to. And look only at explicit definitions by Congress in the Internal Code, we must apply this rule to every word Congress chose to define in that glossary. Okay? Yes, correct. When we do this, a strict statutory jigsaw puzzle comes together. Okay, let's see. The cross-examination of glossary. Okay. If we strictly follow the Fox and Stenberg, we gotta look at standard dictionary to understand what Congress meant. We must look exclusively at 26 U.S.C. 7701. Yes, I agree. So far, so good. Man, you're starting to get there maybe, right? Let's see. Congress provided definition of state in this section, yes. The term shall be construed to include D.C. Yeah, nothing else listed there. Under your strict interpretation, we cannot guess what the operative verb include means by using an ordinary dictionary. Ah, there we go, starting to get there. Stenberg mandates that if Congress explicitly defines that term, we must follow that Congress's definition to the exclusion of all others. Yes, correct. Okay, there we go. There goes that. That includes it getting thrown that in there. Looks like Congress anticipated this exact structural question and explicitly wrote a mandatory definition for the verbs include and including directly into the very same glossary. Okay. Now it starts at okay. Yeah, but they say it doesn't apply. Okay. In section C, the terms including when used in a definition and complaint in this tally should not be deemed to exclude other meanings, otherwise being the meaning of the term you defined. Okay. All right. Apply a strict legal syllogism. If we combine Fox, Stenberg, and Gould under strict interpretation, the mathematical logic of the statute unfolds like this. Fox and Stenberg mandate we must completely ignore the ordinary meaning of the word if Congress has provided clear definition. Yes, 50 states are not in definition of United States or state. You agree right there, right? It's not there. The target text. Congress defines state by saying it includes D.C. Okay? Mandatory tool. Because Congress used the word includes, Stenberg legally forces us to look at Congress' explicit definition, includes, found in 77.1. No. C. Okay? But, see, now let's go back to C again. The literal command section says C explicitly commands us with the word includes shall not be deemed to exclude other things, otherwise be the meaning of the term like 50 states. Okay, well now it says it says why this perfectly satisfied Gould versus Gould. Let's see. Okay, the Gould versus Gould states that we must not extend tax laws by implication or larger operation to embrace matters not specifically pointed out. Yes? If the court rules that 50 states are excluded from a tax code based on 71A910, that court is violating Gould versus Gould. Oh, well, thanks for agreeing. Wait a minute. If the court rules that 50 states are excluded from tax code, court is violating Gould versus Gould? No, it's not. Let's see why. Because to exclude 50 states, the court would have to imply that the word includes means includes only. But that is what Supreme Court says. By making that implication, the court would be completely erasing explicit language of extremes. Do not use this word by to imply an exclusion. No. He's adding stuff in there. Okay, all right. So what I'm going to have to do on this one is to give it other definitions in the Internal Revenue Code, other places. Okay. So here we go, because he doesn't want to go by that. I said, it obviously includes 50 states. So basically, what the Gemini does is say that do not use this word to imply an exclusion. No, that quote does not exist. Okay, I'm going to argue with it. Your quote of all right, let's see what comes up this time. All right. So I'm thinking this time I'm gonna have to. I think maybe I'll talk about Regulation 1.1-1. I'm gonna put that in there and see which United States is talking about. I think I'm gonna do that one. Yeah, we got CFR 1-1-1, right? Yeah, we have it up there. I know we have it on there. Yeah, let's go back. I got it's up there. Actually, I can do that. Yeah. So let's see. Let's go in there to Gemini. Says you're entirely correct. Oh, thank you. I know I'm correct. The phrase, do not use this word to imply an exclusion, is not a verbatim quote from any statutory text or Supreme Court ruling. Yeah, you made it up. It's hallucinating. It quotes something that doesn't exist. Why do you quote it? Gemini, if it's not a quote, why do you quote it? This is an example when they tell you that the AI, artificial intelligence, sometimes hallucinate. It means they make up stuff on their own because they believe in this, they believe in that, they believe in this and that and that and that. So based upon that, they made up a quote that doesn't exist. This is a good example of what they talk about AI. Hallucinating, you got to correct it. Okay, let's see. Presenting that paraphrase summary in quotation marks was an error on my part. Wow, I admitted that. There you go. See? I apologize for that misinterpretation I'm correcting. it hereby by relying exclusively on the exact literal text of the law and the precise definitions provided by the U.S. Supreme Court. Okay. Strict analysis under Gould versus Gould. Okay. To adhere with Gould versus Gould, we must strictly look at clear import of language used and ensure we do not extend or conduct the statutes or operations to embrace or exclude matters not specifically pointed out. Very good. Very good. All right. You get back on your feet again, Gemini. Let us look exclusively at the exact words that are specifically pointed out by Congress into Roman code. Okay, very good. Okay, so it talks about United States. Okay, but it includes only D.C. States and D.C. Following Gould versus Gould, we are forbidden from using any implications. Yes, no implications, no implying. The literal words specifically pointed out as being included in the geographic United States are states and this D.C. Okay. Now, talk about 810, which is defined states. To determine whether the explicit inclusion of this D.C. means the automatic exclusion of 50. Oh, there you go again. Automatic exclusion of states. You're excluding again. We are forbidden by Gould from making an assumption or implication. Instead, we must look at specific textual command of Congress. I don't know. It doesn't sound like the way when you add the word automatic exclusion, everything is automatically excluded. Everything. Unless it's clearly pointed out. That's what the Supreme Court says. You're ignoring Gould versus Gould again. What is specifically pointed out in 1701C. Oh, there we go, back to C. We know what that says about including. Supreme Court's reconciliation. When Supreme Court has been asked to harmonize these exact definitions under strict rules of statutory construction, it has uniformly applied the literal text 1701C to reject the idea that creates an exclusive list. Okay? Gives us since the United States, analyze the definition of IRC state that term includes certain specific entities but omitted others. The High Court ruled that omission did not mean exclusive stating. Though the definition of person in this section does not mention states or any sovereign entity or officer among those includes, it is equally clear that it does not exclude them. Okay, this is made certain by President of IRC that terms includes and including are when using the definition shall be deemed to exclude other things, otherwise be the meaning of that term defined. Okay, and then Groman versus Commissioner, 737. Supreme Court explicitly distinguished between exclusive and non-exclusive definitions, ruling that when exclusive definition is intended, the word means is employed, whereas the word includes. The court directly cites statutory precedents of 1701C to confront includes cannot be used to imply exclusion of other words meaning of the term. Okay, all right. So I'm going to have to just come back to this thing and give it. I think we can save this, can't we? We can save this thing, and what we'll do, save this search, and we'll do a part 2 on this. Okay? So, hello to my truth and freedom-seeking friends. This is the second part of our challenge and discussion with Gemini AI 3.5. As far as we know, it's the most advanced AI available commercially to people like us. So we're going to put the entire conversation up for you as I speak right now. In a minute, my assistant going to, just rather than seeing me, he's going to scroll down from a very beginning, top up where we left off last time, part 1. This is part 2, remember? He's going to scroll down so you guys can see everything that was said by me, everything that was said by Gemini for yourself. And I'm going to give you a quick summary so you understand what you're looking for. I went back and researched to 1913 where the very first federal income tax law said that the word state and United States, okay, shall, include District of Columbia and her territories because such construction or interpretation is necessary to carry out the provisions of the law properly. So, and I showed them that whole including language, which I referred to earlier, came up a few years later when one year Congress took states out of defining. They defined the United States, modified it a little bit, but where state was not redefined like the United States was. And that was done deliberately. Instead, the word state definition of it remained that which was in 1913. The people that wrote the first income tax law after the supposed ratification of the 16th Amendment of the U.S. Constitution, knew that it did not give Congress any new taxing powers. By U.S. Supreme Court decision of Pollock versus Pollock Supreme Court case, it was well established in 1895 that direct taxing of people's interest, dividends, rents, wages would be unconstitutional. If it was unconstitutional then, it was unconstitutional after 16th Amendment, because in two Supreme Court cases, Bruchaber versus Union Pacific Railroad and Stanton versus Baltic Mining Company, Supreme Court said that it did not give any new taxing powers to the government. The 16th Amendment of the Constitution did not give Congress any new taxing powers. Well, if that's the case, then how do they tax your wages, salaries, interest, dividends, rental, your business income? How? Well, that is why they wrote the law for applying to Washington, D.C. and her territories only, because Congress knew that for the law to be properly constitutional, it could not apply to 50 states. And again, Bruchaber Supreme Court case said that Bruchaber argued that the 16th Amendment allowed a direct income tax without it being apportioned or divided among the states as required by the U.S. Constitution. And the U.S. Supreme Court said, nope, that can't be. That is unconstitutional. That would just create confusion and mess things up, because there's a part of the Constitution that says direct taxes must be apportioned, and at the same time, this part of it says that, hey, the tax on income does not need to be apportioned. So for that reason, the Supreme Court stuck the whole law as indirect tax. Indirect taxes by Constitution are only required to be uniform. Tax on oil, tax on import, and other excises must be uniform across America. Okay? So you want to drill so much oil, same rate of tax on drilling a barrel of oil in California, New York, or Florida. You want to import something from another foreign country, from Japan, okay, or France, same rate of tax, whether that enters America from, Georgia or Oregon or Massachusetts. Same rate of tax applies, right? That's what indirect taxes need to be uniform. Well, the rule of apportionment, or dividing up the tax among the states, does not need to apply to indirect taxes. I mean, there's no dividing up apportionment for tax on imports or tax on oil. So it doesn't need to be there. It doesn't even belong there. It doesn't make sense. But Supreme Court said because direct taxes, you cannot have the non-apportioned language in there. While the apportionment language is still in the Constitution, they would be in conflict. That's a no-no. It's indirect tax. That's what we have Supreme Court saying. It's the Sixth Amendment, the 1930 law is indirect tax. Yeah, but it cannot apply to people in 50 states. So how do you reconcile all this? Very easy. Congress wrote the law deliberately to apply only to District of Columbia and her territories. That's what the 1930 law clearly in one sentence says, that the state of the United States shall include, okay, D.C. and the territories, and it is necessary, is required for the proper construction or understanding or interpretation of the federal income tax law for it to be constitutional. Yes. For it to be constitutional, it cannot apply to the people of the 50 states. In fact, the U.S. Supreme Court in Downs versus Bidwell in 1901 said that the federal government can tax the U.S. territories, U.S. lands, in a way that is not applicable to the state, union, 50 states. In other words, direct taxing and indirect taxing restrictions that apply to the Union states have no place at all whatsoever in when it comes to U.S. territories, like Puerto Rico, which was the subject of the Dallas versus Bidwell in 1901. So Congress, clearly knowing that, we must assume they knew that. We assume that they followed the Supreme Court's interpretation of the law, wrote the law for income tax applying only to District of Columbia and her territories. That's why that language, again, in 1913, the very first income tax law, which is still today, says that state of the United States shall include D.C. and her territories, for the proper construction or understanding and constitutionality of the law, because the laws are presumed to be constitutional. Well, the only way for it to be constitutional is for the federal income tax apply to the District of Columbia and her territories. And over the decades, all they did, they took out the territories and left District of Columbia. Therefore, the District of Columbia citizens and residents have to file and pay income tax. That's right, because in D.C. and territories, the federal government was given power to tax any way they want to, because they were meant to be primarily D.C. and her territories were primarily meant to be military installations to keep the new states who got independence from England from being taken back by England by force. Okay? So they said, look, in its military places, do whatever you want. When they wrote the Constitution, there was no District of Columbia to begin with. Later on, they came up with about 10 square miles of land by Maryland, and Virginia was mostly swamp land to drain the water and do what you want on that land. Nobody wants. That's why the limitations of the Constitution, as Dallas versus Bidwell says, do not apply in District of Columbia and her territories. So the law is completely constitutional. The citizens and residents of Washington, D.C. must pay federal income tax, but the people of the 50 states don't. The federal government is a government of limited power given by the states. So go to freedomlawschool.org and start with the law. Follow the law, step one, okay? I got videos on this topic. I'm going to put this discussion on that someplace up there previously because it was very interesting, detailed discussion. I wish our congressman would engage us, would talk about it. Because our congressmen they'll represent you and I. Look, this is what happens. We have our step 4 on our website. If you see it right here, we have question authority, right? We say, write to your members, Congress members, file and pay income tax only if your congressman can show you the law that requires you to file and pay income taxes. This is how you safely free yourself of IRS deception, robbery, and slavery. If you can show you're wrong, the Congress members, by Supreme Court decisions, by laws published by Congress, great. Pay it. I'll pay it. I'm telling you right now, IRS, DOJ, go ahead. Tell me and I'll file income tax. But they don't. I've written my congressman about it. So have you. I visited my congressman's office to try and meet with him and discuss it. Nobody even calls you back. We have phony taxation, pretend taxation, without representation. And these founding fathers had proper taxation without representation. Ours is worse. We have phony pretend taxation without representation. So take a look at it, for example, on our website. You go to step 4, question authority. You don't have to pay tribute to the beast that you don't own in the first place, right? You go on there, step 4 on our website, and here we have, by doing this, keeps you safe. By following the law, you will not be going to prison because you are relying on the law as published by government's own official legal websites. And no federal lawmaker has ever refuted all legal petitions and showed us the law that requires the people of the 50 states to file and pay income or employment taxes. None of them. We invite them. Look, show us. And if you go down on this thing, the petitions are all right there. Here we go. And here's, for example, the petitions. Here we go. Let's see. You all do it yourselves free. Right here. We have fillable free forms for for you to download and send a petition to your Congress members. One is about individual income taxes. Second, about employment taxes. The third one is self-employment taxes and 1099 forms, okay? For single or married people, they're ready to go for you. Of course, we have more information about for yourself of income tax withholding also, instructions. So you look at these petitions and we tell Congressmen, look, I will pay my fair share of taxes. Just show me where I'm wrong. Just show me. I'll pay. Just show me. Just explain to me where I'm wrong. But what they do, they just ignore it. Get out of here, little boy. Come on, come on. Come on, you're taking my time. I'm too busy. Too busy raising money for my next election campaign. I gotta get reelected. I don't have time for you. You just one vote. That's all you are to me. I don't care about you. Your one vote doesn't make a difference for me. I want to get the votes of millions of people, or whatever, large numbers of people, and I need money, money, money to get myself advertised, get elected, right? So, so you go here. Now, let me see the response, for example, this congressman gives. Here's Chuck Grassley. This guy is a Senate President pro tempore, okay? You know what that means? That means this guy, okay, was head of the finance chairman of the Senate. He oversees the IRS. Yes. He's the head of the Senate committee that oversees our correct federal tax laws. Yeah. And yet, when he responds to us, look at his letter here we got here. No, look at it. Does he in any way attempt to address our questions at all? No. Here's his letter in June 2024, okay? Here, look at this signature on the bottom. Chuck Grassley, United States Senator. That's a phony computer signature of Chucky, okay? I value your input. Really? You value my input? What? How do you value it? By ignoring anything I say? By not addressing anything I say? How does your value? It doesn't. Look, and all it does, after he says, I appreciate hearing your concerns in second paragraph, he says, oh, go to the IRS's website. Wait a minute, Senator Grassley. The laws are written by you and you, fellow members of U.S. Congress, the House and the Senate. IRS only executes the laws that you wrote. You are the expert, supposedly, on tax law that wrote it. The author is you. These guys are just interpreting you. But you're abdicating your responsibility, giving it up by saying, oh, talk to this other guy over there. No. You must do your job. They're not doing it. That's why, folks, we got to stop paying income taxes, in addition to the fact that there's no law requiring you to. Why pay this congressman and their political pet projects when they don't even listen to you? They don't represent you. They ignore you. You don't matter. Well, then who do you represent, Congressman? I thought this is the government of by the people, of the people, for the American people. But that's not what we have. And the only way to change that is just like Congresswoman Marjorie Taylor Greene said. Voting is not working. We got to stop paying taxes to these politicians that don't represent us. Right? They are owned by anybody with money from, let's see, the banks, military industrial complex, security complex, oil companies, insurance companies, the Zionist lobby, the pharmaceuticals, any powerful mega corporation with some interest. They go pay congressmen to get reelected and pass laws that favors me and my buddies who help me get reelected. So there's, in America, a class of people like you, slaves, who pay in the system. And they, the Epstein billionaire class, they get to take it out. A friend of mine told me, Peymon, a lot of billionaires, most billionaires in America, to be a billionaire, you have something to do with the government. Some government contract or government favor. You cannot become a billionaire unless you have something, government did something to favor you or your industry or gave you a big favor or break or contract or subsidy. You can be a millionaire, but not a billionaire without U.S. government involvement in rigging the game while you, the American people, are suckered to be paying for your own slavery. So stop paying income tax, folks. freedomlawschool.org. Go there. I'm here to help you. For over 30 years, I have not filed and paid any federal income taxes, showing Americans do the same legally, safely. Not only I've never been indicted, never been to jail for not filing and paying income taxes, but none of my students who came to me and stayed with me, stopped filing and paying income tax with Freedom Law School and stayed with me and followed our procedures, has ever gone to prison. Go to freedomlawschool.org, learn the truth, tell the people you love, your spouse, children, parents, co-workers, friends, hey, here's the truth. Don't believe me. Verify it for yourself. All right?